Well, good morning and welcome to our webinar today, Trustee Selection, How to Choose the Right One for You. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and we're joined by President and Principal Attorney of Elville & Associates, Stephen Elville. We're coming to you live this morning from our Columbia office in the Columbia Gateway community, and we're pleased to be with you. So how this will work today, if you haven't been with us before, you are on mute. However, if you have some questions, please do post them throughout the presentation. We will be pausing periodically to answer those questions, along with leaving plenty of time at the end for more Q&A. You also received the presentation by email yesterday from me for your convenience to take notes on it if you wish. Everyone also received a survey. Will also receive a survey immediately after the presentation. So please just take a couple minutes to fill out this simple survey. It offers us very valuable feedback about the presentation. You also can let us know if you have some information about some topics that you'd like to see in future webinars. And it's also a great time to request a consultation from Steve to discuss your family's planning needs if you wish. So very briefly, an overview about our firm and a bit about Steve. We were founded in 2010 in Columbia by Steve Elville. We have a number of different practice areas here at the firm that we focus on: estate and special needs planning, elder law and elder care planning, a very busy estate and trust administration department, asset protection, guardianship, and tax planning. We have 7 attorneys, 12 staff members in 5 different locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. And we do focus on education here a lot at Elville & Associates, and that's through our planning processes with our clients. We offer well over 100 educational workshops and webinars in the communities we serve each year, and also by way of our accredited client care program through the Client Care Academy in Boston, Massachusetts. We are one of 60 law firms in the country and the only firm in the state of Maryland with that accreditation through the Client Care Academy in Boston. So we're very proud of that. And a lot of our clients do take advantage of the many benefits that we offer through that CCP or Client Care program. So everyone at the firm here works each day with the ideals of collaboration, education, and compassion in mind. And anytime that you work with us or partner with us, you should expect nothing less from us at any time. So those are things that we focus on here at the firm every single day, and we hope you take that to heart when you work with us as well. So we're going to go ahead and introduce Steve here very briefly, because we have a lot to cover. Steve has been an attorney for the past 20 years, and his work has been centered in elder law, special needs planning, and estate planning. He is a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. And his focus always is to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. He was last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar Association. He's a very seasoned speaker, as you probably know, presenting at about 75 different webinars and workshops every year. And last year was named to the Maryland Super Lawyers list for a 5th time in 2020. So congratulations to Steve. So we're going to go ahead and get started with a brief poll to get everybody acclimated to participating. And we hope you do participate throughout the presentation today. I'm going to go ahead and get that off my screen. And I'm going to go ahead and launch the poll. And the poll today is, what has brought you to today's webinar? So I want you to please select the response that applies to your current situation. I'm going to go ahead and launch it, and the answers are, and please select the one that best applies to you, is I am a grantor, I've established a trust before, I've been or am a trustee of a trust, or the last one is I am the beneficiary of a trust. So I'm going to go ahead and launch that poll right now. You should see it pop up on your screen. So please just go ahead and take 30 seconds to select the answer that best applies to you. You may have been more than one of these before, but just choose the answer that best applies to you now. See the responses coming in. Appreciate your participation. Okay, and it looks like we have about 50% saying I'm a grantor, I've established a trust before, 32% saying I've been or am a trustee of a trust, and about 15% saying I am the beneficiary of a trust. So a good mix. So I appreciate you participating. I'm going to go ahead and close out that poll so we can go ahead and turn the screen over to Steve. So just give me about 10 seconds to do that. And Steve will begin the presentation. So Steve, you should see that. Turn it over to you.
Very good,
Jeff. Screen, Steve.
And it looks like I'm taking the reins here, and I'm going to minimize my own picture. There we go. So you should be able to see my slides.
All right, very good.
Thank you so much. And good morning, everyone. And happy Friday morning to you. I'm going to minimize myself again out of the screen. And it's a privilege for me to be with you this morning. And thank you for taking the time out of your Friday morning and your busy lives to sit through this educational program. It is cloudy outside my window, but hopefully the sun will come out today. And my goal here today is to walk you through something that will hopefully end up being a tool that you can use. This particular presentation, if you haven't already received it, Jeff will make sure to send it to you, and you can actually upload this into your own computer and save it as a tool. But by the end of today, my goal is that you will walk away knowing about 95% more than anyone you know about how to select a trustee. And I want to thank Jeff for being our moderator. He's a great moderator, and he will take your questions as we go through. If you have questions, please pose them to Jeff. I will stop frequently throughout the presentation to see if anyone has questions. And again, this is an educational session, and nothing could be more important than trustee selection. We're going to talk about many different aspects in the next hour and a half or so of trustee selection and what a trustee is supposed to do and how to think in terms of selecting trustees. But in my experience in estates and trusts and elder law and in special needs planning, nothing could be more important than the selection of trustees. So again, thank you for being with me. Please have a pad and paper if you wish to make notes, and again, do not be afraid to ask questions. So I'm going to go ahead and advance the slides, and we're going to go to our first slide. So today we're going to talk about what a trustee is and what are their responsibilities. We're going to talk about the types of trustees and their characteristics, the advantages and disadvantages of the types of trustees, if you didn't already know that there were certain types and characteristics. We're going to talk about the perfect trustee, the ideal perfect world trustee, and we're going to set a very high benchmark for the selection of trustees. We're going to talk about why the selection is so important. Not only the selection of initial trustees, but if you look down at the next bullet point, trustee succession and how the overall trust is designed. How is the plan designed? And why is this so difficult? Well, we're going to get into that. One of the biggest problems is that people are not afforded the time to think about these things. So we want to encourage you to spend a lot of time in the design process. If you're already a trustee of an existing trust, we're going to talk about how important it is to take the time to understand that trust. And would you believe it if I said that many trustees are trustees of trust, but haven't even read the trust? So you may or may not be surprised by that. We're going to talk about the various roles that trustees have. What is a trustee role in a will? What are the various trustee roles in a trust situation, like a revocable trust or an irrevocable trust? And what are some of the reasons to consider appointing a corporate trustee? And then what are we concerned about as far as successor trustees and the risks involved with successor trustees. So we're trying to cover a lot of information today. It will become overwhelming possibly during the presentation. If so, I encourage you to please hang in there with me, and you can always ask questions afterwards, or Jeff and I want to be a resource for you in the future to continue to ask questions. So don't be overwhelmed, and let's just move into the material. So what is a trustee and what are their responsibilities? Well, first of all, and this is pretty obvious or self-evident, the trustee's role is to administer the trust. And the role of the trustee in administration is one of pretty much mechanically going through a process during the life or lives of the beneficiaries and at the death of the grantor when a trust needs to be administered initially prior to distribution. And we're going to talk about that. So a trust can be administered during the lifetime of the beneficiaries after it's been established, or it can be a process of administration after the death of the grantor, where we have initial administration before the lifetime administration for the beneficiaries. And obviously, a trustee is supposed to follow the terms and provisions of the trust. And I'm going to make a little bit of an extra comment here, not only follow the terms and provisions of the trust, but also follow them under state law and under trust law. So again, going back to my prior comment, many trustees sadly do not fully understand the trust, and they do not understand their responsibilities, but going back to basics, they haven't even read the trust fully. Trustees must keep accurate records. Now, many trustees do this and do it very well. Some don't do it at all. And then there's always a day of reckoning. And that day of reckoning is when someone asks for an accounting, or where an accounting is required because trustees are moving from one trustee to the next in trustee succession. So keeping accurate records is a very fundamental thing. And it's not easy to do, but it can be done through a methodical checklist or a process. And again, I just mentioned accounting to the beneficiaries. So under Maryland law, beneficiaries have the right to an accounting. They have a right to information. And as we're going to see, there is no such thing as a quiet trust in Maryland, as there are in other states, such as Delaware. So for better or worse, and by law, it's for the better, beneficiaries are entitled to accountings or to information. The trustee must make distributions, either mandatory distributions or discretionary distributions, according to the terms of the trust. And of course, not doing so is a breach of fiduciary duty. So that's an important thing. And the trustee is responsible for making trust investments. And as we're going to see here in a few slides, the trustee doesn't necessarily need to be the person, and usually should not be the person, who is actually making the investments. If it's an if it's an individual who is the trustee, that individual 9 times out of 10 should not be making trust investments unless they are professional. So a trustee would, by definition, hire a financial advisor or a professional to make those investments. So when we say the role of the trustee is to make investments, we do not necessarily mean that we want the trustee himself or herself actually making the investments. The trustee has a duty to communicate with the beneficiaries on a reasonable basis. Beneficiaries, again, are not only entitled to information, they're entitled to communication on a reasonable basis. The trustee has to ensure that all tax filings are complete. So, for example, certain trusts, as we're going to see, are revocable trusts. These are trusts that are identified by the grantor's social security number, and those trusts do not pay their own taxes. And then there are trusts that are called non-grantor trusts. We're going to review this one more time during the presentation. But all tax filings, whether it's a grantor trust or a non-grantor trust, have to be complete. And of course, that would be a breach of duty if the trustee isn't doing that. And then not only making sure the tax filings are complete, but managing assets, taking into consideration the income taxation of trusts. So trusts are taxed in a different way than individuals, depending on what kind of trust it is. So if it's a non-grantor trust, we know that the trust is going to be in the highest tax bracket at a very low threshold that is just slightly under $13,000 of income. So let's say a trust has just under $13,000 of income during the year. That trust is going to be in the highest current income tax bracket, which is 37%, versus the individual brackets for the same income would be much, much lower. So the trustee has to understand this. They have to utilize professional help, and they cannot be in compliance with their duty if they're not taking these things into consideration. Now let's talk about trust basics. So what is a trust? Well, a trust is a relationship that is formed from an agreement between a grantor and a trustee to provide for a beneficiary, the person who benefits from the trust. Now, before we go any further, there are various terms that are related to the term grantor. So when I was a much younger lawyer, the term of art was the trustor or the donor of the trust, and now the more modern contemporary definition is a grantor. So the grantor is a person that creates the trust agreement. The grantor could be the trustee of the trust, or another person could be the trustee other than the grantor. And of course, we have the beneficiary. The parameters and the roles and responsibility of the trustee are contained within the trust agreement under state law. So going down to the bottom of this slide, very basic, we're starting very basic here. The grantor is either the settlor or the trustor. Means the same thing, is the person who is establishing the trust. The trustee is a person, an individual, or a corporate trustee, like a bank or trust company, that accepts the property and manages that property for the benefit of the beneficiary, not in the way they want to do it, but as directed by the grantor of the trust, in the trust. And of course, the beneficiary is the person or persons that the trust was established for, and how the property is used and when it's used and for what purposes it's used. Those things are outlined in the trust agreement. Now, many people are confused by the term revocable versus irrevocable trust. So let's just talk about this real quick at the outset. A revocable trust, and I want you to write this down if you're not familiar with this, a revocable trust is nothing more than a substitute for a will. So to set the stage for what a revocable trust is, when someone does basic estate planning, when that person comes in to talk to an attorney, let's say, and says, I want to do a basic estate planning, a plan, that person is either going to have a will or a will substitute. And so a revocable trust, for example, is a substitute for a will. It is basically a contract, a private agreement. So let's look at this definition. A revocable trust is a trust that can be amended, modified, or revoked, and it's taxed just like the grantor. So if I am an individual, which I am, and I have a social security number, which I do, if I create a revocable trust, that revocable trust is nothing more than a contract. It's an extension of myself, and it is taxed under my own social security number because it is called a grantor trust, which we're going to talk about in a few more slides. But a revocable trust is a basic estate planning tool. It is a substitute for a will. Now, an irrevocable trust is a trust that generally cannot be amended, and you'll notice the word generally there, and it generally cannot be modified or revoked except through a court or an agreement among all the parties. For example, Maryland has something called a non-judicial settlement agreement. A non-judicial settlement agreement where irrevocable trusts could actually be changed in certain ways. And these kinds of trusts, these irrevocable trusts, are generally taxed as standalone entities, and they are taxed either as grantor trusts, where the grantor pays the tax, or they pay their own tax, and that's what we just discussed, at those higher rates. There are ways of managing trust income, and we're going to talk about that just a little bit, but that's a subject for a different workshop. But just understand that there's a difference between a revocable trust and an irrevocable trust. Now, what are traditional revocable trusts? Well, I just described that revocable trusts are substitutes for wills, and basically they avoid probate. Many people have misconceptions about revocable trusts. They think that revocable trusts are magical, or that they are mystical, and they have asset protection, or that they have tax advantages, and nothing is further from the truth. A revocable trust has no asset protection. It doesn't provide any kind of special tax protection. It is basically an avoidance of probate tool. So a revocable trust avoids probate. It is a wonderful tool, but it does not do things like protect from creditors or provide asset protection and avoid taxes. It does not do those things. Now, that's a very, very common trust. Now, also very common are trusts for protecting beneficiaries. Now, these can be lifetime trusts that are established during your life for the benefit of someone else, but many times these are trusts that are established at death. For example, in this first bullet point in the second half of the page, the trust is established for a minor child, and the trust holds property maybe for an adult who has either a spendthrift problem, they spend a lot of money, or they have substance abuse issues, or they have creditor challenges, or perhaps they are in bankruptcy, of course, and a trust can continue forever. So one of the advantages of Maryland law, even though Maryland is not one of the recognized asset protection states, Maryland has no rule against perpetuities, which means that a trust could actually last forever. So we have traditional kinds of trusts like revocable trust, but then we have trusts for people that are established at the grantor's death, or the grantor can establish trusts during life for beneficiaries. Now, there are beneficiary controlled trusts. So there are ways to establish a trust for someone where they can actually be the beneficiary of their own trust. Maryland law allows this through the Maryland Trust Act. This doesn't mean that the beneficiary should be their own trustee, and it does not mean that the beneficiary should be their own trustee forever. Let's say the beneficiary is the beneficiary, the trustee, I should say, of their own trust, and let's say that they actually experience a creditor situation or a divorce situation, or someone is forcing them into bankruptcy. That would not be a good situation for that person to continue to be their own trustee. So in a perfect world, there would always be an independent trustee for someone for asset protection reasons. And there are things we'll discuss in this presentation about that. But many people like to establish trusts because it's allowed by law where the beneficiary is their own trustee. And that is fine as long as the beneficiary doesn't experience a crisis of some kind. But during that crisis, there needs to be flexibility in that kind of trust to allow the beneficiary to be no longer serving as trustee and another person appointed as the trustee. We need to remember that in certain asset protection, or all asset protection trusts, there are exception creditors. So a spendthrift irrevocable trust, we would call it, which is a trust established at death or during life. Creditors such as claims for child support or alimony are not protected by the trust. And claims by Uncle Sam for taxes would not be protected by such a trust. So there are exception creditors, but otherwise these spendthrift trusts do have a tremendous amount of protection for the beneficiary. Special needs trusts are another type of very common trust. These trusts are considered to be discretionary trusts and not support trusts. So as opposed to the trust we might have just been talking about for someone's health, education, maintenance, and support, a special needs trust is the antithesis of that, where it says this trust is purely discretionary on the part of the trustee, and can only be distributed under the following distribution standard. Usually it is what is called a special needs standard or a supplemental needs standard, and there are various ways to make that more conservative or less conservative within the confines of a discretionary trust. So again, a trustee is a person or a corporation who accepts property and manages that property for the benefit of the beneficiary as directed by the grantor. And the beneficiary is the person or persons from whom the trust property is intended to benefit. All right, so let's just take a moment. I'm going to stop so far right here and see if Jeff has any questions so far.
Thanks, Steve. We do have a few questions. And the first question is, I think, a two-parter from the same gentleman, a good friend of our firm, Joe. Hi there, Joe. Will we learn the risks of being a trustee? And to piggyback that, what are the legal liabilities?
Yes, that's a great question. Set of questions, Joe. Yes, we're going to talk about trustee risk and responsibilities. Yes, a few of the things we've already covered so far, if you review the materials afterwards, and I know I'm throwing a lot of information out there, are part of the trustee's duties and responsibilities. So we're going to continue to talk about that, in addition to the risks.
Another question, does the accounting to beneficiaries in Maryland need to be on a time frame such as an annual time frame?
That is a wonderful question. Thank you. So in my opinion, all trustees should render an annual accounting. In a perfect world, we would do that. Now, it's been a trend that I've seen, and I'm not saying it's a good or bad trend. I don't say it's very good, where I see a lot of trustees and even corporate trustees not rendering an accounting until there is a request from the beneficiary or from someone else involved. So I would say in a best practice, a trustee always wants to have an accounting ready and always should render an annual accounting so that it can be reviewed. But I think a lot of trustees are not rendering an accounting until is requested under the reasoning, I guess, there is that they're saving the trust money. But I think in full disclosure, in a perfect world, there should be an accounting every year.
Thank you. And one more question. Can you again state what was the Maryland law called that allows changes to irrevocable trusts?
Yes, and thank you for that. It's called a non-judicial settlement agreement. Non-judicial settlement agreement. And that's just one method of changing otherwise irrevocable trust that we all, for many, many years, would think cannot be changed without court involvement. So there are techniques, and we're going to talk about a few of those today, where a trust that's irrevocable can actually be changed, and that's one possible way of doing it.
Okay, thank you. That's it for now. Thank you.
Thank you, Jeff, and thanks for those questions. So let's just spend just a minute or two. What is a grantor trust? Well, a grantor trust, and remember the grantor trust rules, for those of you who really want to torture yourselves with research, you can go to the Internal Revenue Code, section 671 through 678. 671 through 678, these are called the grantor trust rules. And they're very complex, and they're used in various ways. But the simple thing for today to remember is that a grantor trust is a trust where the trust does not pay its own income taxes. The grantor does. And a non-grantor trust, and I'll give you one example. Let's pretend that someone passes away and leaves a trust for the benefit of a child or another beneficiary. That irrevocable trust at death is going to be a non-grantor trust. That simply means that trust is responsible for its own income taxes. It has its own tax ID number, its own EIN, and it will file what is called a Form 1041, which is a fiduciary tax return that will measure the income of the trust on an annual basis. So a grantor trust, the grantor pays the tax, not the trust. A non-grantor trust, the trust pays its own tax. All right, now we mentioned the non-judicial settlement agreement, which was established under the Maryland Trust Act, which was very, very important. And it was established, the Maryland Trust Act was established in 2014. So most of this is archival material for you, but a few things about the Maryland Trust Act I wanted to make sure that you were aware of. So in Maryland, up until the time of the Maryland Trust Act, beneficiaries were not entitled to notice. They were not entitled to information per se. So Maryland finally did away with that and said, listen, beneficiaries under an estate are entitled to notice. So now beneficiaries under a trust must receive notice. So the people who are entitled to notice are called qualified beneficiaries. And you'll see a simple definition here. This is a current distributee of the trust or a current beneficiary of the trust. This is not the complete definition, but this is very simple. Or a would-be distributee of the current distributee's interest if that person's interest were terminated. And the Maryland Attorney General if it's a charitable trust. So this is not a full definition, but I'm just trying to give you a little bit of a flavor for what a qualified beneficiary is. And there are certain notice requirements. So a beneficiary, a qualified beneficiary, must receive notice of the creation of a new irrevocable trust within 90 days, the trustee's responsibility. And Joe had mentioned, Steve, what are the trustee's responsibilities? Well, here's one of them: to provide notice within 90 days of the creation of a new irrevocable trust. The trustee must notify all qualified beneficiaries of the appointment of a new trustee within 60 days of appointment. And then, as I mentioned earlier, these notifications cannot be waived. And therefore, there is no quiet trust in Maryland. Now, there is a way to appoint a representative, someone who would receive notice for a beneficiary. And many people think that that means that Maryland is actually sanctioning a quiet trust. But a further investigation into that would reveal that it's really not a quiet trust and that the beneficiary is still entitled to notice and information. So what are the rights of a qualified beneficiary? Well, in a nutshell, they can request the following things: a copy of the trust, annual reports of the trust, and reports upon the termination of a trust or a trusteeship. So just know that we can no longer in Maryland not provide information or notice to qualified beneficiaries. Now, what is the role of a financial advisor? Now, I mentioned this earlier. I'm not suggesting that every single one of you who are listening, who are trustees or non-trustees, that you have a financial advisor. But what I am suggesting is that if you are a trustee and you're carrying out your fiduciary duty, you most likely would not be making investments yourself, and you would be hiring a professional. Because remember, you as a trustee have fiduciary duty. You have a duty, and we're going to talk about some more of the duties of the trustee. And that means that you're probably going to hire a professional to do the management of the trust assets. Because remember, you do have a duty to manage trust assets. And so as we are talking about the selection of a trustee, what I'm hoping you're doing now is you're taking all this in, not only as trustees of trust now, but what to look for, which is the topic of today's presentation, what to look for in the selection of trustees. And as you consider who the trustees will be, put this kind of information into context of what that person's job is. Their job, in my opinion, unless they're a professional advisor, is to hire a financial advisor and to make sure that they get something called, and you can write this down, an investment policy statement. Your trustee should be protecting themselves and protecting the trust by not only hiring a financial advisor, a professional, but getting an investment policy statement from that financial advisor that they are understanding the role of the trustee, the trustee's fiduciary duty, and they are investing the trust assets in accordance with a fiduciary standard. And we're going to talk about that in a little bit. So what is this role of financial advisors? Well, they may open an account in the name of the trust, and they would. And they would be concerned about, is there just one trustee? Are there multiple trustees? If there are multiple trustees, or even if there's no multiple trustee, but maybe the beneficiary wants to receive a statement, is the financial advisor going to send out a duplicate statement? Is the trustee going to use a checkbook or a debit card? Obviously, they would use a checkbook. I'm not sure whether they want to use a debit card or not, but again, they have an accountability no matter what method they're using. And how is income being distributed or reinvested? And is the trust being funded with in-kind assets? What if a trust is being funded with a piece of real estate? What if a trust is being funded not with cash, but with existing investable assets that have just been transferred in kind from the deceased person, let's say, into the trust account? And the trustee has to make sure that the financial advisor and the financial advisor has to make sure that all assets that are inherited that are supposed to receive a cost basis adjustment, that those assets are stepped up within the account. And for those of you who are not familiar with that, remember that, for example, non-retirement assets, investments such as mutual funds or stocks, upon the death of someone, they receive a cost basis adjustment to fair market value. The trustee has to understand these things. The trustee has to work with a financial advisor in these things. The trustee has to work with the financial advisor in the management of the trust portfolio and to make sure that the trust is properly allocated. We have a case that we've been involved with recently where a trustee is involved who has not had the trust property properly allocated over the years. They've had the trust investments geared to a certain direction that is in contradiction to the terms of the trust. So these kinds of things can happen. And the trustee needs to be open to advice. So here we see in the middle bullet point, the financial advisor or the investment person needs to advise the trustee about their fiduciary duty with regard to the investments. And we're talking about the prudent person rule or the prudent investor rule. And the financial advisor also has to understand that there may be a need to have a certain amount of investments available, a certain amount of cash available, and not having everything invested all the time. There may be ongoing needs where the trustee has to be able to access cash. So your trustee has to understand this role with the financial advisor in well over 90% of the cases, because in my view, a lay person who is a trustee, a non-professional, should not be managing the trust assets. Now, Joe had asked, what are the trustee duties? And I think this particular slide gets right to the heart of that. A trustee in a perfect world, and I keep asking Jeff to please put a picture of a perfect person on here, someone who is a perfect trustee, but he just hasn't found anyone yet. But Jeff, have you found anyone? Anyway.
I'm not sure that there is a perfect person out there, but I think we found somebody in one of our other presentations. I should put that person on here, and I will next time.
Put their picture on here. But these concentric circles really indicate that we want a trustee who understands what is best for the beneficiary, communicating with the beneficiary, promoting their best interests. And in the top circle, let's say this was a special needs trust or a special needs beneficiary. This person who's the trustee would need to be an advocate, understand public benefits and so forth. But let's say it's not a special needs trust. It is a health, education, maintenance, and support trust, or just a trust that's discretionary, but it's for a neurotypical healthy person. We want a trustee who understands how to keep accurate records, keeping beneficiaries informed, complying with statutory duties, understanding the financial side and the tax compliance side, and understands the need to use the trust funds to hire professionals to help them fulfill their duty. We want a trustee who understands these things. So trustee selection, after all of those preliminaries, why is it so important? So here are a few reasons why it's so important. Well, first of all, I want to say something that's not even on this slide. The term trust, okay, it implies a certain relationship, if you can imagine. So a trustee is a person who has to be a person of great trust without being facetious. A person who is a go-to person, a person who understands the management of money and understands fiduciary duty, a person who has their own life in order so that they can take care of the trust and the fiduciary duty of the trust. So trustee selection is very fundamental to making a trust work. Because remember, a trust by its very nature is a private instrument. I remember as a much younger lawyer, clients coming in to see me that would say, Steve, why should I have a trust versus why should I have a will? A very fundamental discussion. And I remember saying to them that if you choose a revocable trust, for example, you need to have a trustee that can carry out the duties of the trust because it's a private document. So that's what I want to emphasize to you. Trustee selection is incredibly important because trusts are private, except for the requirements of Maryland law now about qualified beneficiaries and information to beneficiaries. And trusts must, by definition, have a trustee that has the capacity to carry out their fiduciary duty. All right, trusts can now last forever. So we mentioned that Maryland no longer has a rule against perpetuities. So trustee selection is very important because trusts can last hundreds of years if they have that many assets. Trusts are portable. A trust could be moved from the state of Maryland to Delaware, or from Maryland to California, or Maryland to Nevada, and vice versa. So the situs or location of trusts can change. States are in competition for trusts. States are in competition about who offers the best trust services. So for example, our neighbors in Delaware have tremendous asset protection laws that Maryland doesn't for the use of trust. South Dakota, for example, for those of you who love trivia, South Dakota has, to my understanding, more money under management in trusts than any state in America combined, any asset protection state combined. Beneficiaries these days are likely to move around. They're likely to change where they live, okay? So where the beneficiaries are is a big question in the future. That's why trustee selection is important. Trustees have options. They don't have to serve. So what if you appoint someone and they decide they don't want to serve because you didn't follow through to make sure that this was really a solid choice? That's why we're going to get into the issue of successor trustees and trustee selection. Decanting. Trustee selection is important because we now have something called decanting. And it's not just decanting wine, for those of you who are wine fans. Decanting is the hottest thing in estate planning across America for the last 5 to 7 years. And if you haven't heard of decanting, decanting is a way for an independent trustee to actually change an entire trust into a new trust. And this can be very scary if you've never heard of decanting. So we want to make sure that our trustees understand what decanting is, what its limitations are, and how can we, as grantors or the grantors, protect themselves from a trust decanting that actually could change the trust completely, and in some cases even remove beneficiaries. So I know many of you will write this down and have questions about decanting. You should have questions about it, and if you've never heard of it, I encourage you to find out about it. Maryland does not have decanting yet. Delaware, Virginia, and several other states do have decanting. So I just want you to know that it exists. It's one of the things your trustee should know about. It's one of the reasons to be selective in your trustee selection. And flexibility in changing circumstances. We're living in a changed world. We're living in a very scary world in some ways and a challenged world. So we want to select trustees that understand the need for flexibility and have flexibility in our trustee selection in general. Now, I'm going to stop for just a second and see if there are other questions.
Thanks, Steve. We do have a couple. It says, hi, Jeff and Steve. Happy Friday. Thank you. Same to you. What is your experience naming multiple trustees on an irrevocable trust?
Okay, thank you. So I'm going to try to interpret what I think your question is. I think what you're asking, and you can please clarify with Jeff, when we appoint multiple trustees, and I'm assuming you mean 2 or more trustees, and hopefully not more than 2, because I find that gets a little bit dicey there if we go more than 2 co-trustees. But I think that my answer would be this, that's going to be very good as long as those, as you've been thoughtful in your trustee selection process. Who are those co-trustees? Do they know each other? I've actually met people who want to name co-trustees that have never met one another, and they live in different states and they're not even related in any way. So I think everything is fact specific to your particular situation. Generally speaking, I would assume you would not name those multiple or co-trustees unless you thought they would get along well. And I'm assuming that you would name co-trustees because you have a reason for it. In your mind and heart, you have the feeling that I need these co-trustees. And I think I want someone, a group or 2 of trustees, so to speak, that will act together. There's reasons why I want them to have to act together. Now, remember, co-trustees can act jointly or they can act individually. They can act jointly or individually. In other words, they can act unilaterally. All of this is a counseling issue. There is something called a trust protector, and it just so happens that on this slide, at the bottom bullet point, you'll see trust protector. So if I were naming co-trustees on a long-term basis in an irrevocable trust, I would make sure that I have a trust protector, which we're going to go over in greater detail, because a trust protector can remove a trustee if they're not working together in harmony in a co-trustee situation, or if they're not fulfilling their fiduciary duty to the grantor, and the trust protector can replace that trustee with another co-trustee. So I think long-term co-trustees are going to be fine as long as you've been thoughtful and as long as you build in flexibility.
Thank you, Steve. Another question. I'm going to read it slowly. It's a good question. If funds are in a revocable trust that gets converted into an irrevocable trust on death, then into 2 legacy trusts for children, does this still follow the cost basis adjustment rule?
That's a great question. And if I'm hearing it right, at the death of the grantor or grantors, when a revocable trust is administered, and it goes through this administration process of filing final tax returns, accounting for all assets and so forth, accounting for all expenses and income, and then it's distributed into 2 further trusts. The non-retirement assets, the assets that are not IRAs, they are not 401ks, those assets get a cost basis adjustment. Yes, if that's your question, it gets a cost basis adjustment to fair market value, generally speaking, at the death of the grantor, and therefore the child will not have to incur income tax. So I think the answer to that is exactly that.
Very good. One more question, Steve. Is a corporate trustee more beneficial as insurance against the occasional bad trustee mistake, Or is a corporate trustee generally cost effective for any trust?
That's a great question. So we're going to go through a whole slide here in just a second about corporate trustees. I'll just say at the outset that my experience with corporate trustees as an attorney has been very good. I know that other estates and trust lawyers sometimes have various opinions about corporate trustees, but generally speaking, I have found them to be good. I have found some banks that are somewhat big banks to be less than a stellar in their approach, but I find that generally speaking, corporate trustees are pretty good, relatively speaking, and we're going to go over the advantages and disadvantages of a corporate trustee. Yes, they are expensive, and I think that depending on the size of the assets that are to be managed, you definitely want to be selective about how that relationship is going to work, especially if you have smaller assets, which I'm not saying that you do. If you have smaller assets, then a corporate trustee can be a real drain on a trust, but we're going to talk about that.
Okay, we have another one or two that just came in. So I'd like to pose these to you since I think they're on topic. So as grantor, I could have two trustees. I have two children, and current trustee wants to discontinue, feels he's too old. Also, is it problematic when trustee or trustees live out of state?
Great question. So if you have a current trustee who doesn't want to serve, that person can resign. And of course, it's specific to you. If you are talking about a revocable trust, then remember you can always change your revocable trust and amend it and appoint whoever you want as the successor trustees. If it's not a revocable trust, then we have to look at what the trustee succession is and whether or not there are mechanisms in a trust to be able to have one trustee resign and then two other trustees become trustees. So yes, your two children can serve as co-trustees if that makes sense after some counseling and discussion. And I apologize, Jeff, what was the second question there, part of that question?
Also, is it problematic when trustees live out of state?
Oh, thank you. So I would say that with today's technology and cell phones and smartphones and email and text, I think it's not generally a problem for your trustee to live out of state. If, on the other hand, we have a trustee of a special needs trust or a trust for someone with enhanced needs of some kind, trustee geographics might be more important. But generally speaking, it's not going to be a problem for a trustee to live out of state. It's not ideal, but it is generally not going to be something you can't overcome.
Okay, and last question for now, Steve, regarding decanting. Can decanting be used in a positive way to support beneficiaries? Next says, if comes about or when in Maryland?
Great question. So I know the Estates and Trust section of the Maryland Bar, and I'll answer the last question first, is considering a decanting legislation, and I apologize, it may have actually been proffered last year to the legislature right in the middle of COVID-19, and there was no expectation that decanting was going to be passed in Maryland. And decanting, if it is passed in Maryland, I can almost promise will be very conservative legislation. It will be the opposite of something like Nevada that has had very aggressive decanting laws. But I'm expecting probably in the next 2 to 5 years, Maryland will have a decanting statute. And the answer is yes, decanting can be used in a very powerful way for good. And what we try to do here at Elville and Associates is advise clients about recognizing the good and bad things of decanting and then making sure we've addressed that in some of the trust documents. So one example of how decanting could be used for good, and I'll use the special needs trust example. Let's say that unfortunately someone has received an irrevocable trust for their general needs. They're a healthy person, and they have that trust for 8 or 9 years. and then that person, God forbid, is in a car accident or they have a brain injury, and now they have special needs. Well, decanting could potentially be used to change that general needs trust into a special needs trust. So that's one of the positive things that decanting could be used for. All right, in the interest of time, thank you for those questions. I'm going to now continue. So the trustee selection process continued. This may be very easy for you. You may have a very short list in your mind. My children, my siblings, my other relatives, my brother-in-law who is a CPA, or my brother-in-law who is an investment banker, whatever it may be, this could be easy for you. But let's talk about the difference between interested trustees and independent trustees before we jump into this. Remember that many people want their beneficiaries to be protected from the claims of creditors, or they wouldn't be using trusts. These are trusts at death or irrevocable trusts. And so if that beneficiary is their own trustee, and remember I said earlier that Maryland will allow that, well, that's all great. The problem is that in some other states, they view that as very silly. They say, how in the world could a beneficiary be the trustee of their own trust and still have spendthrift protection? So we have to be concerned about who the trustee is, not only who they are as a person, but what is their relationship. So a sibling, for example, who is a trustee for another sibling is an interested trustee, just as if the beneficiary were the trustee of their own trust. So we want to build in flexibility to have independent trustees, because in a perfect world for asset protection, all trusts would have independent trustees, whether that's an independent person or a corporate fiduciary, because we know overall throughout the country that the various jurisdictions, we know this would provide the greatest asset protection for the beneficiary. Now, the selection process is best done during document review. Now, if you already are kind of inheriting a trustee role in an old irrevocable trust, there's nothing you can do about this. But if you are thinking about selecting a trustee and you're in the process of implementing trusts, or you're in the process of reviewing and revising trusts, you need the time to think. We talked about that earlier. You need the time to visualize this situation, discuss it, think out long term, way in many years to come. How is this going to play out? Who should be my successor trustees? Should I build an independent or corporate trustee into that selection process? Even educating the trustees that you're appointing during or selecting during the planning process. We're big believers here in educating fiduciaries, because if you have an educated fiduciary, you have a plan that's actually going to work the way you want it to work. We need to recognize conflicts between certain potential trustees. So siblings, for example, it may sound like a great idea, but it's really not a great idea 99 times out of 100 to have one sibling as trustee of another sibling's trust. Now, every situation is different. And again, individual independent trustees versus corporate independent trustees. Very, very big, very big thing. Advantages and disadvantages. So let's talk about that prior bullet point, individual versus corporate trustees. The individual, if it's an interested person, this could be a lay person, it could be a family member. Well, that's not going to be the end of the world, but probably not ideal, okay? Versus a corporate trustee who is used to having to file tax returns every single year. They are regulated, okay? They have had to set their fees according to the Secretary of State. Generally speaking, there is Maryland law, and then a corporate trustee would have to get their fee schedule approved by the Secretary of State. The corporate trustee, which we're going to talk about in a few minutes, might have a few more advantages than the individual. But again, the offsetting disadvantage is the cost. But then again, we have to look at the individual and realize they are entitled to compensation as well. So looking at this through very clear lenses on both sides of the fence. Trust protector provisions. What is a trust protector? And I may be a little redundant here and getting ahead of the other information, but the trust protector is a special fiduciary. Now, I don't want to get too far into the weeds, but a trust protector can serve in a fiduciary or non-fiduciary capacity. But in Maryland, it must be a fiduciary role where they have your highest and best interest, or the highest and best interest of the trust in mind. And the trust protector, generally speaking, has the following powers, although there is no limitation on their powers. The trust protector can generally appoint or remove trustees. That's a general responsibility of a trust protector, to remove and appoint trustees. A trust protector can change a trust by amending a trust administratively for administrative reasons like tax or ambiguities within the trust or some other administrative reason. Now, in a special needs trust, the trust protector's role could be expanded. Or any trust, the trust protector could be given the duty to mediate disputes between beneficiary and the trustees. The trust protector could be given the right to demand an accounting. The trust protector could be given the right to, again, back to taxes, make changes to a trust, for example, due to the Secure Act and some of the things that the Secure Act has brought to the table in not so great ways for people who are saving for retirement. So these are some of the considerations. And we talked about interested versus independent trustees. So again, an interested trustee is defined by the IRS code, and we just simply can think in terms of people who are subordinate to the beneficiary, relatives, siblings, those kinds of people, versus independent trustees who are not subordinate, independent people like a CPA, a friend, a professional, an attorney, or a corporate independent fiduciary like a bank or trust company. Different standards of distribution. Let's talk about that very briefly. In many of our documents, we draft that if there is an interested trustee, or let's say the beneficiary of a trust for themselves, for their health, education, maintenance, and support, that is called an ascertainable standard. And there's reasons why we use that in a trust for a person who is their own trustee or they have an interested trustee. But if that same person had an independent trustee, we would have a different standard of distribution, because we know that an independent trustee could distribute on a discretionary basis for any reason. And I don't expect you to fully grasp that, except to remember that where we have an independent trustee, we can provide for greater asset protection. So there are different standards of distribution, different points of view between an individual that's interested versus an independent person, different levels of objectivity. Some people will say to me, Steve, I don't want my family members handling my affairs. I don't want to put that burden on them. I am much happier having an independent trustee do that. Different levels of oversight. I'm not saying an interested trustee wouldn't provide oversight, but an independent trustee is more a professional organization or a professional person who's providing oversight versus the lay person. These are considerations. And then the practical considerations, someone mentioned a few minutes ago, what if we have an out-of-state trustee versus an in-state trustee? Who will be here for the beneficiaries upon my death? So these kinds of practical considerations. For example, Elville and Associates has a trust group, and so for individuals who are looking for trust services or trustee selection, our Waypoint Trust Group is here. We sometimes serve as independent trustees of all kinds of trusts in all kinds of situations, or just to help a trustee in certain situations. So we want you to be aware of that as part of this presentation, that Elville and Associates does serve as trustee, co-trustee, trust protector in those kinds of roles, or we are supporting trustees in various services to trustees. Now, we talked about the trust protector, and I said it was going to be somewhat redundant, so please let me give you this particular slide. The trust protector, in my opinion, is a special fiduciary whose job is to further the intention of the grantor. Let me repeat that. A trust protector, in my opinion, is a special fiduciary whose job it is to further the intentions of the grantor. They have to act in a fiduciary role. Some people will say, Steve, where did trust protectors come from? What is this all about? Well, my best explanation is that trust protectors are a product of the asset protection states across the country. So Delaware, Nevada, South Dakota, Alaska, Wyoming, several states around the country, about 16 of them are what we call asset protection states. And trust protectors came from those states because in those states, unlike Maryland, you can actually establish a trust, and this is called a self-settled trust. You can actually establish an irrevocable self-settled trust that will actually protect your assets during your lifetime versus a revocable trust in Maryland, for example, where there is no asset protection during your lifetime. So trust protectors came from those more exotic trusts. Now in Maryland in 2014, as you know from this presentation, we have the Maryland Trust Act and the trust advisor, which is, in my opinion, very similar or the same thing as a trust protector, was now put into the law. So Elville and Associates was using trust protectors in documents even before 2014, but now you can have a trust advisor / trust protector in your document. And basically it is a power of amendment. It is a power of a special fiduciary like a trust protector to say to the trustee, I have been given very limited powers and I'm directing you to amend the trust in the ways that I've been empowered to do so. And again, we talked about the power to remove and replace trustees, the power to direct the trustee, the power to mediate disputes, to compel accountings and other things that the trust protector could be charged with as their duty. So a trust protector, what is the big deal? The trust protector, in my view, provides flexibility to the trust, especially where we're leaving trust long-term for beneficiaries, or if you're the trustee of an irrevocable trust that is like a dynasty trust where it's going to be lasting for years and years into the future, trust protectors can be very, very valuable to not only deal with tax changes in the laws, but other flexibility measures that might be needed. Jeff, I'm going to stop one more time. We've got about 20 minutes. And are there any further questions or should I persevere on?
Thanks, Steve. Do have just a few questions. Could you please explain again how trusts are taxed differently than an individual?
Great question. And I'm going to try to do this without the benefit of a whiteboard or some visual material. And I apologize, we may include that next time. So I want you to imagine that an individual is subject to the new tax rates or the marginal tax rates. And there's various charts that you can see on the internet that will show that way up into the $500,000 or $600,000 range, an individual would have to earn that much money to be in a 37% tax bracket. So imagine that an individual has to earn a lot of earned income under the 2017 Tax Act to be able to be taxed at the 37% rate, which is the highest rate right now. But in a trust that is a non-grantor trust, a trust that pays its own tax, that trust will be subject to 37% tax at a very, very low threshold. And I believe that threshold right now is $12,800, slightly less than $13,000 of income. So many of you may be in shock right now and say, well, Steve, who in the world would want to create an irrevocable trust that subjects the beneficiary to 37% or 39.6, which is the old rate, tax at such a low threshold? And the answer is that Uncle Sam compresses the tax rates for non-grantor trusts, and there's nothing we can do about that. But what we can do is realize that trust income can be passed out to the beneficiary. So if you imagine this circle I'm holding up as the trust, and it's got X amount of dollars of income that has been created in the taxable year. And remember, that is measured by Form 1041, which is the trust tax return. So we have X amount of dollars of income, but if that income is distributed out for the benefit of the beneficiary, either to the beneficiary or for the benefit of the beneficiary, now the trust does not pay that 37% tax, and the beneficiary would pick up that income on their own tax return. So generally speaking, your trustee that you select has to understand that, because if they don't understand that, they will cause the trust to have to pay too much tax. So that is a function of something called distributable net income, DNI. So whatever the income of the trust, depending on what kind of trust it is and how the trust is written, and this is a very general explanation, very general, non-specific, DNI, distributable net income that's distributed out of the trust, zeroes out many times the tax of the trust so that the trust does not pay the 37% rate, and the beneficiary will pay the tax at a much lower rate. All right, Jeff, any other questions right now?
Yes, sorry, I thought I was on speaker there. A two-part question, and then we can move on. Should we have both a will and the revocable trust, and why? And the second part is, what is the trust equivalent to a codicil in a will?
All right, so I'll answer that last one first. The trust equivalent to a codicil of a will is an amendment. So a revocable trust can be amended. Now remember, irrevocable trust cannot be amended unless it's provided for by a trust protector, or there's some other method that is used, like decanting or a non-judicial settlement agreement or other type of mechanism. Yes, if you have a revocable living trust as your basic estate plan, then what I want you to do is think of your revocable trust as the driving force of your estate plan. And that revocable trust should be funded with your non-retirement assets. As a backup to your revocable trust, you're going to want to have a will that recognizes the existence of the trust, and that is strictly a backup document. So yes, a typical revocable trust plan will have a will as a backup.
Very good. Let's do one more for now. With two children who are beneficiaries and who are both responsible and who get along well, that's great. Are there any reasons not to establish them as co-trustees?
Well, if I interpret your question properly, I would say no, there's no reason not to appoint them as co-trustees in the event of your incapacity and powers of attorney or attorneys in fact under a power of attorney. And there's no reason not to have them as co-trustees and at the time of your death so that they can administer your trust. But if you are leaving further trusts for them, I would say that probably it's not ideal to have them as co-trustees of each other's further trusts, and to have a flexibility mechanism or an independent trustee for those trusts. Very good question.
Okay, let's try one more. Must a trust protector be identified in the trust at the outset?
Great question. The answer is yes. You either want to identify who the trust protector is, or you want to identify who will appoint a trust protector in the future if you don't want to identify who the trust protector is. And lastly, if you don't want to identify a trust protector or a mechanism to appoint a trust protector, you by virtue of a person appointing the trust protector, you could have a backup provision that says, I want a trust protector to be appointed if one is needed, and a court can appoint one. But I personally would not rely on that particular last choice.
And along those same lines, Steve, should you have a succession plan of trust protectors?
And the answer is yes. And you can, some of you may smile when I tell you this, but you can take this issue as far as you want. You could say, here is my trust protector, or the appointer, so to speak, of a trust protector. Here is my second person, the backup person. Here's my third person, who's the backup person. And you could even give these backup individuals the ability to appoint another trust protector. You could also have a provision that says, I've allowed for all these trust protectors, but I'm also authorizing another person to actually be able to remove trust protectors. So I think it's just a matter of how much backup planning you want to do, as funny as and sometimes unrealistic as it may sound.
And this trust protector idea has brought about a lot of thought here. When a trust has provisions for a trust protector, how is that provision activated to recognize when a trust protector is needed and designated?
Thank you for that question. And then I promise we will move on in the presentation after this question. That's a great question. So one of the problems with not appointing a current trust protector and not having that trust protector be active, so to speak, to interact with the beneficiaries or the grantor during your life or the life of the beneficiaries, is that the trust protector role tends to be passive. And many people want to do this because it is cost effective, because you don't want to have a lot of cost, let's say, during the beneficiary's lifetime. On the other hand, the trust protector serves in a fiduciary role, but can the trust protector really monitor the lives of the beneficiaries? And the answer is no. The trust protector cannot realistically monitor what is happening in the lives of the beneficiaries. So you want to educate, number one, your beneficiaries to know who the potential trust protectors are, and make sure that they have their contact information. In a perfect world, you will appoint trust protectors and you will mandate that after your death, that the trust protector and the beneficiary will stay in touch with one another at least annually. All right, so we're going to move on now, and thank you for your patience as we answered those questions. I want you to think now, after I know this has been going on now for about an hour and 20 minutes, I want you to think about the role of trustees. We've talked about how to select trustees, but let's talk about their roles. So in a will, let's say that a person has a will. That will could leave everything outright to spouses and beneficiaries, and there's really no role for a trustee. But a will could leave what is called a bypass or marital trust, and I'll just call these spousal trusts on the death of one spouse. So there would need to be a trustee of a bypass or marital trust. And this could be the spouse, or this could be the spouse and children, or spouse and independent trustees. A person who has a will could pass away and leave a trust for young beneficiaries that are no more than 25 or 30 years old. And you're very familiar with that. So this is a role of a trustee. Now, what if a person dies and leaves a trust for a beneficiary? And we talked about this. That trust is for the benefit of a beneficiary, and they are trustee of their own trust. So under a will, we call an irrevocable spendthrift trust a testamentary trust. So a trust under a will is an irrevocable testamentary trust. And here, this particular trust has a spendthrift clause that means that the beneficiary is protected. They cannot assign or give away the trust assets, and that gives the trust integrity, where the creditors, unless they are exception creditors, creditors cannot get in the trust. And here we have the role of a trustee in the last bullet point as trustee of an irrevocable trust for another person. So the trustee could be their own, beneficiary can be their own trustee, or they could be the trustee of another person's spendthrift trust. Now, what are the roles of trustees in a revocable trust? And many of you have revocable trusts on this call. I've been able to ascertain that by your questions. So we know a revocable trust is a living trust. So the living trust, remember, has a living element. It's not just a trust that handles things at death. One of the things that most people who have a revocable trust do not realize is that their revocable trust has a lifetime component. What if you become disabled? So here we see that the role of the trustee of a living trust could be during the lifetime of the grantor or after death. So we have the same situation here, but the difference between the will and the revocable trust is if the grantor becomes incapacitated during life, here their successor trustee, and this is very important for trustee selection. Your trustee steps into your shoes and does what? Manages the trust for your benefit during your life. But also, of course, they administer the trust after your death. Here in the second bullet point, we have the same thing we had in the will situation. There could be a bypass or marital trust for the surviving spouse. Third bullet point, we could have trust for young beneficiaries, or in the last two bullet points, we could have further trust, maybe even what we call dynastical trust that lasts forever, established under the trust, under the revocable trust, and the beneficiary can be their own trustee in Maryland, may or may not be advisable. And the trustee could also be the trustee of an irrevocable trust created under the revocable trust for another person other than themselves. Now, I know we've waited a long time to talk about corporate trustees. So some people prefer to appoint a corporate trustee based on experience. Many corporate trustees will also be the money managers. So an argument can be made, and each situation is different, and you have to interview corporate trustees and understand what they're all about. But if they're managing the money and being the trustee, of course, their fee could be wrapped up in that kind of packaged approach. So experience, asset management, they are regulated by state and federal government. Many times they are reliable, and sometimes you might be disappointed in certain corporate trustees, which is why you want to not only get professional advice and counseling about this, but you want to interview corporate trustees, in my opinion, sometimes in conjunction or in the same conference room with your attorneys or CPAs. They bring objectivity. They can be a referral hub. I think a good corporate trustee knows a lot of resources and has a lot of resources at their disposal. Some people appoint a corporate trustee as a backup because that corporate trustee would be around supposedly for a long time and bring some peace of mind. So corporate trustees have their ups and downs. I think good selectivity on your part and asking this question if it were me. And again, I know that some of you are trustees of already existing trusts, and you're thinking about how to manage your responsibilities, and you're looking at this information to help you along those lines. But some of you are considering how to appoint trustees and how to select them. And I think along those lines, you have to be very selective in today's world and sit down and make these corporate trustees show you their relative advantages versus the competition. Who will be here on the ground in my community, in my city, who will be here to support my beneficiaries if I name you as my corporate trustee? That's what I would ask. Now, one of our last slides here, and Jeff, I think we're going to be able to end by an hour and a half, subject to further questions, is why should you be concerned about something I've called successor trustee risk? Well, remember that it's a big task, and I know many of you are on this webinar because you're struggling with this issue. Who should I appoint as trustee? It's a big deal just to come up with one person who would be the go-to person, or the go-to independent person, or the go-to corporate fiduciary that will fulfill your plan and actually make your private plan work, your trust of whatever nature that it is. And now we have to be concerned with successor trustees. So we want to make sure that not only our primary trustees are up to the task, remember those three circles and the perfect trustee, but now we have to be concerned about Who are my successor trustees? Where will they be living? One of the things, not only where will they be living, but what is their life situation at that time? Will they be married or divorced? One of the things I want to bring up that may not seem obvious is the same issue that many people do not think about when they are planning. And this may help you in the trustee selection situation. If you look at your planning, if you're thinking about planning or revising your planning and you're selecting trustees, if you think about your planning as an ongoing process, for example, Elville and Associates has a client care program that Jeff had mentioned. Our reason for having the client care program is not because we are doing that as a revenue generating tool. What we're trying to do is we're trying to encourage our clients to come in and update their plans on a regular basis. Because we know that if we don't see clients on a regular basis, they don't have the opportunity to reconsider things like, who is my successor trustee? We can't predict in the future at an unknown time where you will be, where your trustees will be, unless we are doing it on a more regular basis. So I guess what I'm trying to say, to lessen the risk of successor trustees and all the things that could or may not go wrong, update your planning on a regular basis for the rest of your life, and you're in much more control of this element of successor trustee risk. So age and experience of the successor trustees. Older trustees, many people are concerned, who do I name? Because I'm already up in years or getting older, we all are, and I know my own health is not what it used to be, and my brother or whoever it is that I'm going to appoint, his health may deteriorate over time. Remember that most trusts do not require the trustee to actually obtain a bond. So in most trusts, you're going to be forgiving bond, and that just means the trustee won't be bonded. And so you've got to think in terms of, if I don't update over a period of years, what if this successor trustee's life changes and I don't make a change to my documents? So is there an element of risk there? What are their life changes? Divorce, creditors, bankruptcy, unforeseen things like COVID-19, for example. What if my trustee is disconnected with the needs of the beneficiary? So remember, that would argue in favor of a trust protector. The trustee's not doing their job, so that element of risk could be managed with a trust protector who could remove that trustee if they weren't doing their job. What if the beneficiary is really demanding? How many of you have served as trustee or are serving as trustee and the beneficiary is extremely demanding? At times you feel like, well, I don't want to do this anymore. Well, what if a beneficiary was so demanding that the trustee that you chose as your successor trustee just says, I'm not doing this anymore, and they resign? So you have to take all of this into consideration. And again, you can't control everything, but you can control what you could do if you have a trust protector who can deal with these things in the future. My prior comments have to do with the next bullet point. Make sure your trustee is willing. Make sure they have the fortitude, not only the experience, but the fortitude and the perseverance to do what is necessary. I know a wonderful lady who was the trustee of a trust for years and felt that it was her duty to fulfill the wishes of a relative. And she was not happy being the trustee. She was not happy having to be very diligent with the trust when the beneficiaries were very difficult to deal with. But she persevered until she had a health issue. But that person was dedicated. She was ready to be the trustee. You just have to take this into reasonable consideration. And lastly, trustee compensation. So many of you will want to know, how can a trustee be compensated? We talked about corporate trustees and how they represent a certain expense and how they have a model. And it's usually for larger assets that this makes more sense. For assets of any size, the trustee compensation can either be under state law, which is rather limited, and it's a contemporary view that trustee compensation under state law is probably not in your best interest or the beneficiary's best interest because it would be too limited. So many contemporary trusts today are drafted with something called trustee compensation that is reasonable compensation. And you may ask yourself at a time when you are creating documents or creating a trust, how do I determine what is reasonable compensation? So that is kind of a counseling discussion. But all of these things you want to take into consideration is, will my successor trustee be there? And will I have made the right selection at that time? And have I covered all the downsides of successor trustees by installing flexibility into my plan, for example, a trust protector or other protections? So Jeff, I think I've gone slightly over 12 o'clock. I'm going to end on this slide. So I have really enjoyed talking to you today. Thank you for listening and being here and asking your questions and taking such an interactive part of the discussion. Jeff and I enjoy it very much when you are active. I would like to give you next steps, as what we're known for is not just providing information, but giving people next steps. So we want you to set an appointment to discuss your trustee selection if you have issues on your mind, and it's all for your unique situation. We want to give you the options and review all the options, which is what we're known for, which is educating clients. We want to educate you and your potential fiduciaries. We want you to consider us a choice for your independent trustee if you are having a problem determining who the trustees would be. Or we can help you decide which corporate fiduciary or other independent trustees should be trustees, or whatever trustee arrangement you desire. We want you to take action to implement changes to existing documents and take action to implement changes to new documents. So with that, I wish you a wonderful weekend ahead, and I'm going to turn it back to Jeff.
Well, thanks, Steve. Do have, before we finish up, just a few questions. I'd like to try to answer those questions before we finish up. First question, is there a financial obligation to a trust protector, or do they receive a fee? The second part of that question is to explain the Secure Act, and I will preface that by saying perhaps I could send out your article about the Secure Act as well as your podcast, as I think that could be about an hour and a half webinar in and of itself.
All right, thank you. So, Jeff, I do think that's a good approach to the Secure Act, and I apologize to the person asking the question that the Secure Act is just far too broad to discuss today. But to answer the question about trust protector compensation, trust protector compensation is going to vary depending on what document the trust protector is installed in. So for example, in a Delaware trust or a big asset protection trust in Alaska, a trust protector would usually be compensated annually at a certain fixed rate, because they have an obligation to actually meet with, in most cases, to meet with the trustee and other trust fiduciaries in those types of trust on an annual basis. On a local basis, or a more conventional estate planning scenario, which I think most of us on this call are probably talking about, a trust protector could be compensated on an annual basis, or more normally, a trust protector would only be compensated for the time they are spending either meeting on an annual basis with the trustee, or actually doing something that relates to their job of fixing a problem, or demanding an accounting, or removing a trustee, God forbid if they had to do that, if they had to do that or take action. So it would probably be, in most cases, in my experience in Maryland, it would be on an hourly basis when needed.
Thank you. Can Medicaid take assets at death of special needs trusts?
Okay, that is a great question. The answer is no. If it is a third-party supplemental needs trust, and by using that terminology, I mean it's a trust that is established by someone other than the special needs beneficiary, and assets of that person or persons are left to the trust directly and not to the beneficiary. However, there is something called a first-party special needs trust, and this is a trust that is designed to hold the assets of the beneficiary if the beneficiary receives assets they should not have received. So if that kind of first party trust has to be created, then Medicaid has the right to recovery as the first beneficiary of that trust at the time of the beneficiary's death.
Thank you. How can you protect assets accumulating in a revocable trust? For example, if excess assets at the time of death, etc.
Well, let me try to read into that question. So you can't protect assets in a revocable trust in the traditional sense of protecting them from the claims of creditors. What you might be asking is, how can I protect assets from probate? So remember, we want to, on an annual basis or a semi-annual basis, we want to review your revocable trust and make sure all assets are funded or retitled into that trust if they are non-retirement assets. We don't want IRAs or 401ks to be retitled in the name of a trust. That would not work. The other thing you may mean in your question is, how do we make sure assets are protected from estate tax? Well, remember, whether you use a will or a trust, assets are not going to be sheltered from estate tax for you during your life. So we just want to make sure that assets are less than 11.58 million per person if you are a single person, or less than 23 million if you are married. And in Maryland, if you're single, 5 million is the limit. And in a married couple situation in Maryland, 10 million. So when you say protect assets, I'm just trying to extrapolate on what you might mean by that. Hopefully that helped.
You alluded to this, but how often should trusts be reviewed with your attorney?
Great question. So I would start at the statistic that's most shocking, which is that 80% of people who are under age 44 have no will or no estate plan. So now if we go above 44, we know that probably 55% of Americans have no plan, and only about 45% of Americans overall have an estate plan. So that means that the minority of people have an estate plan, and even those people do not update their planning. They don't update it for about 19 or 20 years at a time, to make a long story short. So taking those set of stark facts, we want to, at least if you're over age 50, 55, or 60, we want to start reviewing the estate plan at least every 2 years. And that's what our client care program is designed for, is to encourage people to update. So for example, changes in the law, such as the Secure Act, changes in the law, such as the spousal elective share, which is a new law this fall. These kinds of changes would precipitate very important potential updates to a trust, or something more simple like was just raised. How do I make sure that my assets are continuing to be protected from probate or whatever protection we're talking about? And if we update over time, at least every 2 or 3 years for the rest of your life, once you get over age 55 or 60, now we know the chances are extraordinarily high your plan is going to work the way you wanted it and the way you envisioned it to work.
Very good. And the last question, Steve, and then I'll wrap it up. How is Elville and Associates offering appointments at this point in time? In person, virtual? You could extrapolate on that a little bit.
Thank you very much for that question, and I'll be brief. So Elville and Associates is seeing clients now at our office, and I would say about 50 or 60%, if I had to guess, of our clients are comfortable coming in and for personal appointments. We have a COVID-19 policy. We've had it reviewed by outside counsel. We are doing everything we can to keep clients safe and our staff safe. Our staff rotates in on a rotation basis every week. We have a protocol when you come into our office. Our office and our conference rooms are sanitized, such as the one I'm sitting in right now. So many people are feeling comfortable coming in. Some people do not feel comfortable coming in. So we have virtual meetings by Microsoft Teams mainly, because Microsoft Teams has been sanctioned by the governor as being safe. And what I mean by that is secure. And so Microsoft Teams is how we do most of our appointments virtually. And of course, we can do telephone appointments as well. Then, thanks to our governor, we are able to have document execution by remote means. So we have documents that can be notarized remotely, documents that can be witnessed remotely, and executed remotely without having to come into the office. So we're doing everything we can to keep people safe. And depending on your situation, we'll do it virtually or in person.
Very good. Thank you, Steve. Well, like to give Steve a virtual round of applause for a job well done. And thank you as the attendees and our audience for all the really great questions, which always make the presentations very worthwhile for everybody, and keep Steve on his toes as well, since he doesn't see the questions ahead of time, but a job well done. And just to round out today's presentation, I'm going to be sending you a few items. I will resend the presentation to those of you who did not receive it. I'll also send out the video when it becomes available later this afternoon. I'll also send out a link to Steve's really good article about the Secure Act, as well as the podcast that he did about the Secure Act as well. So you'll be getting a few things from me later today. Lastly, we do have some webinars coming up. On the 28th, 2 Fridays from now, Steve is going to be talking about what elder law attorneys are advising clients in 2020. We also have estate planning for the surviving spouse with Olivia Holcomb-Volke, one of our partners here, on Tuesday the 1st, and estate planning essentials with partner Nicole Livingston on Wednesday the 2nd. And we have a number of really great guest speakers coming in for the fall that we're very excited about, and we'll be announcing soon. So lastly, please take just a couple minutes to fill out the survey that's going to be coming your way in a couple of minutes. And we look forward to being a resource to you as well. And thank you for your continued support of our Elville workshop series or webinar series. And we hope you have a really wonderful weekend, and we look forward to hosting you again soon. All right, we'll call this one a wrap, Steve. Have a great weekend, everybody.
Thank you, everyone.
Take care.